Nika.
This is Nico,
This is Ralph.
And this is Thea.
And welcome to Sasankaments.
your infotainment channel where we discuss
Real office scenarios with real legal issues.
Join us and together, let us answer the question,
Si Duarte, o legal practice under the Philippine labor law, or si Sante, on a legal practice.
Now let us dive into our first question. Will I get fired for not responding to my boss while I'm on sick leave? Before you answer that question, allow us to share with you the two types of employment termination. And first off, will be the termination of employer, which we believe our case falls under. And then another would be the termination by employee, or in simplest terms, resignation. But I guess that's a topic for a different time. So let's expound on the termination by employer. And unlike in other places like in the US, where they have an at-will employment doctrine, here in the Philippines, you can only terminate an employee with only a just or an authorized reason. And thus, terminating an employee in the country is taken very seriously and can be a complex process, especially since, when in doubt, labor code in the Philippines is construed in favor of labor or in favor of employee. So what are the reasons that can be considered as just or authorized to terminate an employee? And according to Article 282 of the Labor Code, it can be any of the following. Number 1, serious misconduct or willful disobedience. 2, gross and habitual neglect of his duties. 3rd, fraud or willful breach of the employer's trust. 4 would be if he committed a crime or offense. So let's go back to our case. Will I get fired for not responding to my boss while I'm on sick leave? And I guess it's just healthy to dissect this point by point under the Article 282 of the Labor Code. So for our first point, we don't believe that this is a serious misconduct. Even if it's not on sick leave. I mean, not responding to your boss can be tagged as slow or inefficient, but in any workplace, it's never been classified as a serious misconduct. So I guess for the first point, it checks out. For the second point, at least for our specific example, we don't have enough evidence to say that this is an habitual neglect of his duties. So for the second part, our opinion is this is non-conclusive. For the third point, similar to point 2, we believe that this is non-conclusive. We don't have enough evidence to support that this is or this is not a fraud. So for the third point, same with point 2, non-conclusive. Now for the fourth point, is it a crime for not responding to your boss? And your boss may say that this is a crime based on his or her point of view, but under the law of the Philippines, even outside labor law, it's never been a crime to not respond to any of your peers in the workplace. So for the fourth point, it also checks out. And those are the factors under the Article 282 of the Labor Code. However, under the same Labor Code, Article 283, employers can also terminate an employee based on authorized causes like business and health reasons, such as installation of labor-saving devices, redundancies, retrenchments, and even closure of operations. So as long as these items are not into play, and based on our discussion under the Article 282 of the Labor Code, our verdict for our case quoted, will I get fired for not responding to my boss while I'm on sick leave, would be
My boss retracted my promotion when he found out I was pregnant, saying that I won't be able to go on field work to perform my duties. Is it illegal? According to Labor Code, employers are responsible for providing equal employment opportunities regardless of race, sex, and creed. It also recognizes the special needs of women as workers and as mothers. With that, the Labor Code makes it unlawful for an employer to discriminate against any female employee with respect to terms and conditions of their employment solely on account of sex. Our law stipulates that employers cannot dismiss or discriminate against an employee on the assumption that pregnancy will affect their work. This includes pay raises, promotions, and other benefits that a regular employee is entitled to. Employers also cannot discharge female employees while on leave or in confinement due to pregnancy. So, no, your boss cannot retract your promotion for the sole reason that you cannot perform your duties by being pregnant. My employer transferred me from our provincial office to our main office with the same position and wage. Is this legal? Let's first define what a transfer means in the labor law context. A transfer is a movement from one position to another of equivalent rank, level, or salary, without break in the service, or a lateral movement from one position to another of equivalent rank or salary. Transferring an employee from one place to another is not by itself unlawful. It is within the inherent right of the employer to transfer or assign an employee in the pursuit of its legitimate business interests. However, this right is not absolute. Transfer becomes unlawful whether it is motivated by discrimination or in bad faith, or is effected as a form of punishment or demotion without sufficient cause. It should also not involve a demotion in rank or a decrease in salary, privileges, and other benefits. So in this case, if the employer can provide proof that the transfer is not unreasonable, inconvenient, or prejudicial to the employee, the transfer is warranted.
Wow, these questions are really interesting, and I believe a lot can relate to the next one. They asked, I was tasked to create a marketing plan, but my company refused to execute my idea, and the competitor company offered me a regular employment and agreed to fund the execution. Is it legal? In our employment contracts, we have what we call reasonable restraint of trade, or also known as the non-compete clauses. It serves to protect the employee's conduct during and after the employment period. A non-compete clause provides that an employee shall not work or engage in work either as an employee, agent, or consultant with any person whose business is in direct competition with the company for a reasonable period from date of resignation or termination. Every individual should be able to pursue their employment or business interests, but not to the extent that it carries away the company's trade secrets, customer connection, and employee records. The manner of time and geographic location is really important to determine the reasonableness of the restraint. The restraint of trade can be void if unreasonable in some circumstances, and that includes unfair clauses, due beyond protecting legitimate business interests, and only agreed to a bargaining power. If the idea contains trade secrets, company plans, and connections being revealed, it cannot be executed to a direct competitor. Let us say you own the plan or idea, but according to the Republic Act number 8293 or the Intellectual Property Code of the Philippines, Chapter 6, Section 178.3, the copyright of the work created by an employee should belong to the employer if the work is the result of the performance of his regularly assigned duties, unless there is an agreement expressed or implied to the contrary. In this case, I'm sorry, but it is going to be
I did not sign and return to my employer the BIR form number 2316 they issued to me. Is it legal? Good day, fellow classmates. Today, we're going to talk about something that can make even the most confident business owner break out in a cold sweat. It's not running out of coffee, although that is terrifying. It's the taxation of employment income in the Philippines. Taxes can be confusing, but as would-be employers or as employees, it's our responsibility to understand and comply with the tax laws of our country. The Philippine government imposes income tax on all income earned by individuals, including employment or compensation income. Compensation or employment income means all financial pay for services performed by an employee for his or her employer under an employer-employee relationship, or simply put, a pure compensation earner. This includes salaries, wages and honoraria, allowances, commissions, director's fees, de minimis benefits, and taxable bonuses, pension, retirement pay, and fringe benefits. Employment income in the Philippines is subject to a withholding tax system. This means that the employer is required to withhold and remit the employee's income tax to the BIR on behalf of the employee, also known as substituted filing. The withholding tax rate depends on the employee's salary and tax status. If you are presently employed, I am sure this form is familiar to you. The BIR Form 2316 or the Certificate of Compensation Payment, Tax Withheld, which proves that an employee's pay was subjected to income tax. Going back to the earlier question where the person concerned, for whatever reason, did not sign and return the BIR Form number 2316 issued by his employer, well, for now, he may be in trouble. Every year, the BIR requires employers to submit a copy of the said form around every end of February. Although for last year, the BIR announced that they still accept the said form without the actual signature of the employee, provided that it is signed by the authorized representative of the employer. For this year, no announcements were made. So, our verdict is that might be a bit harsh, but if an employee does not return a signed copy of the BIR Form 2316 to their employer, it may cause delays or issues in processing their tax returns or claiming tax refunds. The signed copy serves as a proof that the employee received their form and acknowledged the accuracy of the information on it. Furthermore, failure to comply with tax requirements may result in penalties or fines imposed by the Bureau of Internal Revenue. It is important for employees to comply with tax regulations and promptly submit all necessary documents to their employer to avoid potential consequences. In the past, income tax has been a nightmare to understand. The Tax Code of 1997 is filled with all kinds of tax rules and exceptions that even accounting students end up crying when they take taxation classes. It's way too complicated for people like us, but the government is trying hard to keep things under control and stick to the principles of simple, fair, and efficient taxation. The Tax Reform for Acceleration and Inclusion Law, or the TRAIN Law, lowered the income tax rates for most Filipinos. This means that more of our kababayans are able to keep more of their earnings without having to pay as much in taxes, which can help stimulate economic growth and provide more disposable income for individuals and families. The income tax rates in the Philippines are now progressive, meaning that the higher the income, the higher the tax rate. Currently, there are 6 income tax brackets in the country for those earning compensation income, ranging from 0% for those earning up to 250,000 per year to 35% for those earning more than 8 million pesos per year. So for example, if you are earning annually exactly 400,000 pesos, your income tax is a basic rate of 22,500 pesos. And if you are earning annually 410,000 pesos, your income tax would be the basic rate of 22,500 pesos plus 20% of the 10,000 pesos, which is 24,500 pesos. Now what about if you are your own boss or self-employed? That is, you have a business or you are a professional and your income is solely derived from it. You have two options: pay the graduated rates as shown previously, or pay a flat rate of 8% tax based on gross sales receipt and other non-operating income in excess of 250,000 pesos. How about if you are a mixed income earner, where you are earning an income both from compensation and from self-employment? In the new tax law, you will be taxed accordingly by, for your compensation income based on the graduated rates, and your business or professional income will be taxed like that of the self-employed, having the two options if your business is earning not more than 3 million pesos. But if that business income exceeded 3 million pesos, you have no option but to pay the graduated rates. There are several items not included in your taxable gross income, such as but not limited to retirement benefits, pensions, gratuities, etc., compensation for injuries or sickness, miscellaneous items like prizes and awards, and 13th month pay and other benefits but not exceeding 90,000 pesos, and Pag-ibig, SSS, and PhilHealth contributions. Now for the next question. At my previous company, I produced a simple training manual for public speaking, which is not a part of my regular duties and responsibilities. I am now using it at my current company to help my colleagues. Is it legal? In the Philippines, intellectual property rights are protected by law, and this includes the intellectual property created by employees in the course of their work. However, employees should be aware of their rights and limitations when it comes to their intellectual property. In this video, we'll explore what intellectual property is, how it applies to employees in the Philippines, and what you can do to protect your rights. Intellectual property refers to the creation of the mind, such as inventions, literary and artistic works, and symbols, names, images, and designs used in commerce. These creations can be protected by various legal mechanisms such as patents, trademarks, and copyrights, which give the owner exclusive rights to use, sell, or license their creations. Under the Republic Act 8293, or the Intellectual Property Code of the Philippines, when an employee creates intellectual property in the course of their employment, the default rule is that the employer owns the intellectual property. This is known as the work for hire doctrine. However, there are some exceptions to this rule. For example, if the employee created the intellectual property outside the scope of regular duties, the employee may have some rights to the intellectual property. Here is exactly what is written in the law. Section 178.3. In the case of work created by an author during and in the course of his employment, the copyright shall belong to A. The employee, if the creation of the object of copyright is not a part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. And B. The employer, if the work is the result of the performance of his regularly assigned duties, unless there is an agreement expressed or implied to the contrary. So, for the question earlier, where he used a training manual he produced before in his previous company, which is not a part of his scope of employment or regular duties, the person concerned may legally do so, as he owns rightfully the copyright. And the verdict is... To protect their intellectual property, employees should be aware of their rights and limitations. If an employee creates intellectual property that they believe they have a right to, they should consult their employment contract and seek legal advice. If the employee and the employer have a disagreement over intellectual property rights, they can pursue legal action or alternative dispute resolution methods, such as mediation or arbitration. If an employee's intellectual property rights have been infringed upon, the employee may have the right to seek legal remedies, such as an injunction to stop the infringing activity, damages for the harm caused by the infringement, or an order to destroy any infringing products or materials. In conclusion, employees in the Philippines should be aware of their intellectual property rights and limitations, as well as the potential remedies for infringement. By consulting their employment contract and seeking legal advice, employees can better protect their intellectual property and ensure that they are properly compensated for their creations.
And we are down to our last two questions. They asked, I am starting in a new company and the HR informed me that they will be doing a background check and they are asking for some personal information. Is it legal? Well, the Republic Act number 10173, or also known as the Data Privacy Act of 2012, is a policy that aims to protect all forms of information that covers both natural and juridical entities involved in the information processing. Its primary functions are to protect the privacy of individuals while ensuring free flow of information to promote innovation and growth, regulate the collection, recording, organization, storage, updating or modification, retrieval, consultation, use, consolidation, blocking, erasure, and destruction of personal data. And lastly, it ensures that the Philippines complies with the international standards set for data protection through the National Privacy Commission. Information and communication technology in the workplace is a vital role in the company's operations and processes, but it should also bear the obligation that personal information of employees and even customers and clients are secured and protected. All companies must be responsible in protecting confidentiality and promoting availability of data for legitimate use. Therefore, all companies should have a data protection officer, procedures and assessment to ensure data protection, privacy, and data policies to regulate proper handling of information, and a proper procedure in case of data security breach. And to answer the question, yes, it is legal. Background checks are allowed if needed by the employer as a legitimate exercise of the company. They can do this to learn about the candidate's employment or criminal history. But processing must require the applicant or the employee's consent, especially if sensitive personal information is involved. To sum it up, personal data must be collected with consent, will be used for the intended purpose. Third one is employers must have legitimate business reasons and this must be clear to both parties. And employers should have a proper procedure of data privacy from collection, handling, and disposal of all personal information. And with that, the verdict is
And that's it for today's episode. Join us again next time.
For more Sisante and Sinuerte stories in the workplace.
again, this has been Mika, Ralph, Nico, and Thea.
Thank you for watching Sentiments, your infotainment channel where we discuss real office scenarios.
With real legal issues. Bye!
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 Bye-bye.
Take, take, go.